All right, with all due respect, welcome. Tonight, the Supreme Court dance starts officially with a pre-trial conference dispensing and issuing directions on important questions. We now know the Supreme Court has drawn up 9 key questions for the determination, ranging from the question on technology deployment and transmission of results to questions around scrutiny of specific polling station ballot boxes and whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential elections. Now, in the next few days, promises to be defining, and that decision by the Supreme Court will, of course, determine the political roadmap of what happens next in this lovely country of ours. Tonight, with all due respect, we'll try and make an attempt to make sense of the processes that the country is about to witness at the Supreme Court. I have lawyer Elisha Ongoya, senior lecturer, Kabrak University. Karibu sana to the program. Seeing you after 200 years. And obviously, Professor Bigaya Ketch, public and international trade lawyer.
Thanks,
gentlemen,
James.
Without much further ado, we've had a lot, we've listened to a lot. I think the question is, what has happened today? Let me start with you, Elisha. What has happened today?
Let me just paint the bigger picture. A courtroom as a forum for resolution of disputes is a very organized forum. It's actually the classical definition of civility. So what happened today was setting the platform for that order, for that organization, through a pre-trial conference. At the pre-trial conference, the court then sets the ground rules and just restates them, because many of them are actually in the rules. So it restates them for the avoidance of doubt and gives guidance on how it intends to conduct itself. As you can imagine, our law on resolution of presidential election disputes is time sensitive, and that time is really limited. So the court has between now and Monday next week to hear all those people you saw pontificating there and to think through what they have said.
Is that enough time?
That's a reform question we can deal with later.
Yeah.
But the court has no such luxury of asking, is this enough time?
Right.
The court must pronounce itself on a determination by close of business next Monday. So you can't achieve that feat without putting your feet down and pronouncing the ground rules in a manner that does not render you rude, but you must be very firm. And I think you saw that even in the Chief Justice. She appears polite, but very definitive, very firm. So that's exactly what happened today, setting the ground rule and ensuring that everybody understands what is expected of them in terms of conduct, in terms of time to be taken, in terms of whether you will be heard or not, in terms of the order in which the parties will be heard. You are given your slot number so that no one says, I thought otherwise. So that has been completed today. We are trusting that tomorrow things will roll out to Friday. Then the court can have Saturday and Sunday to think through this and draft something, then read it to us on Monday, and we have to live with it.
Prof, everyone has claimed victory of sorts today from all sort of reliefs that are, the court and the judgment. Explain to us really what is this sort of who's won today, who's not supposed to have won today, because everyone really says this is the best thing that has ever happened, and that can't be true, obviously.
No, it can't be true, but I like football analogies. When you're going to play a game, you have to show your opponent that you have a strong team. So some teams sing. So there was a lot of singing today from both sides that we have the best. We have the best team, and can you see the court is actually agreeing with us today? I think the court, yes, it was mostly about getting ready, but the court made some really consequential determinations. We say in law that process determines substance or the outcome. So depending on how a court handles procedural issues, it can influence, shape, determine, you can choose your adjective, the outcome. And for me, the most interesting one related to who represents the IEBC. So first, and there was a bit of confusion if you were watching. First of all, I think it was the DCJ coming to say that it's not the court's business to determine who represents the IEBC.
Yeah.
It's an internal issue that the court won't be drawn into. Then she says, oh, please ignore what I just said. And then says, we allow the application. The application was by the team led by the former AG Githu Muigai. And to say that the notice of appointment that was filed by the renegades, if you can call them that we strike it out. Essentially, the court has determined that the petition as filed that we will listen to is the one that was filed by one faction of the IEBC.
Right.
And not the other. Whereas you could have said initially, as the DCJ had said, let this be an internal issue, or let this be something that comes out. We listen to both sides. It will come out from the proceedings, but let everyone be heard. So I'm not too sure that that won't be seen as process appearing, and I'm trying to as you can see, I'm trying to weigh my words very carefully.
Yes, yeah.
Process appearing to determine the substance.
Right.
Yes, so there is, but that is the issue, because clearly one side of the divide was very happy with it.
Absolutely. And just to bring this, I think to bring it to reality, the question here is the question and the contestation here is who actually represents the IEBC, and both sides had teams to represent their side of the story, but still, to move this forward, the court allowed the affidavits and said, the 4 commissioners are at liberty to appoint counsel to sort of, represent them.
But it's not the same, because it matters how the IEBC as a commission, as an institution, frames its case. Its case, it's either that we conducted an election according to law, which is what one faction is saying, or we didn't, which is what the other faction is saying. Telling them that, you can file affidavits, you're filing affidavits responding to an issue that has been framed in a particular way. And now the framing is according to the faction that believes that the case was, the election was conducted by law.
I see.
But let's clarify this.
Right.
They didn't get the opportunity to file the affidavits today. Remember, the IEBC had already been joined as an institution, as a corporate body to this petition. Its chairman, Wafula Chebukati, had been joined as such, as Wafula Chebukati, chairman IEBC, to this petition. Each of the other commissioners had been joined by name as a respondent to this petition. So those 4 commissioners had, in that capacity, in that individual capacity, in their name, already filed their affidavits. What the fight was here was who would control the narrative of the body corporate. But in terms of the individual narratives, they have already filed them and filed their submissions. So the struggle here was who will take control of the narrative of the body corporate, the IEBC. And it's important to understand this. Not much claim has been made about the transgression of the person who was declared president-elect in the conduct of these elections. Much allegations have been made about the conduct or misconduct of the body called IEBC and its chairman. That's right. The bulk of the claims in this petition all around there. So whoever controls the narrative of the body corporate called IEBC was of interest in that context. And it's important that people understand that's why the struggle was there. Now, Prof, there was a problem here. If the court had stuck to the line, and I kept telling somebody that from a litigation point of view, the court must always remember that it cannot run away from this dispute. Of all those people there, whereas they are all expected to behave maturely because they are senior counsel and they are lawyers of repute, the biggest person in that forum is the court itself. It's the one in charge of that platform. So imagine a scenario where the court says, okay, it is your business as IEB sort yourselves out. Then when the hearing starts, and the court says, now it's the turn for IEBC to present its case, your 3 hours are running, and 2 advocates stand up and begin some drama. Somebody must resolve that problem. It is the same court.
Right.
So the court was not going to stay with this narrative of it is your business.
It was a problem for the court.
The court had to sort out that problem one or the other. And just like Prof here, I'm also waiting for the written ruling, because having had the verbal one, the one that was read, I've quite a bit of clarifications to seek. I can't make much commentary on it. When I get the written one, I'll read it and make better sense out of it.
All right, Elisha Ngoya, Professor Migai Akech, that's just a taster. You're watching with all due respect. We'll take a short break. When we come back, we want to discuss the process moving forward and what we've seen today at the Supreme Court 2022, which proves to be a testy political and legal contest, if you like, however you like to see it.
Mivida Garden City, a residential development within Garden City offering stunning 1, 2 and 3 bedroom apartments, unique amenities and an urban green convenient living. Call us today on 0722 123 000. Mivida, my home, my life.
Hi there, my name is George Washuri and I'm here to really thank you for buying this unique property, the great Oasis Garden. You have done the Maram Road, you have done the subdivision, and now your individual title is ready. We are now processing title deeds for phase 2, just next to the proposed biggest family entertainment center, the GMC, directly opposite this Mount Kenya Wildlife Estate. This particular road you see is Nanyuki Lumuruti and is proposed for tarmacking. Call us on 0790 300 300.
We asked Kenyan women to tell us what they look for in a lotion.
Warembo, ni nini muhimu kwenu mnaponunua body lotions?
Smoothness, scent, glow.
Leo tunaweka kwenye jaribio body lotion ya bei ghali na ya bei nafuu.
Ungenunua gani?
Ina transform dry skin kuwa deeply nourished na smoothen. Na fragrance nayo. Wacha tu. Why pay more? Nunua nice and lovely body lotion. Ni bora zaidi kwa bei nafuu.
It's just nicer and lovelier. Chagua Kenya's #1 body lotion.
Did you know that the hospitality industry is one of the world's leading employer?
We offer internationally recognized certificate and diploma courses in culinary arts, pastry and baking, hospitality management, tourism. Join us today and let us make you a professional. Cascade Institute of Hospitality, an oasis of excellence.
Difficult times ahead for the business. But with all that being said, I really need to finish this meal. Okay, I'll have one.
First you twist it, and then you lick it, and then you dunk it, and then you eat it.
Unapohisi maumivu, unahitaji kitulizo kinachotegemeka. Jaribu Panadol Advance. Ikitumia teknolojia Panadol Optizorb, tembe hiyo hufyonzwa haraka na kuandaa kitulizo cha haraka dhidi ya maumivu. Jaribu Panadol Advance.
Mama, mnamfanya nini huko? Mbona una whisper? Ish.
We, si atukai. Si tumetoka hospitalini na ati wewe peke yako ndio unaweza tupatia ruhusa ya kuwa na mic.
Monica, will you marry me?
African Institute of Research and Development Studies offers you an opportunity to start your career journey with us. Admission for September-October 2022 intakes is ongoing in all our campuses in Kericho, Nakuru, Lodwar, Eldoret, Kisumu and Bungoma.
Welcome back. I have Elisha Ngoya, senior lecturer at the Kabarak University, and Professor Migai Akech. Gentlemen, we're talking about the centrality of this, case, but there were 9 issues that the Supreme Court finally distilled and said these are the issues that we are going to, questions that we are going to consider and, somewhat base this entire 2 days, if you like, to this session. Prof, walk me through that 9 issues and what do you see, because we're all trying to make sense of what are these 9 issues and what is the most, if there is a list of sorts, if this is the most important issue to focus on and that sort of thing.
Exactly, and I'll tell you my sense of what is most important. Because at the end of the day, we either had an election or we didn't. And that should be demonstrated by the records before the court. So if I were to rank them, from my perspective, I would, the last issue, the second last issue, the last issue is on, I mean, so what reliefs, what orders will the court give? But the second last issue, issue number 8, were there irregularities or illegalities of such a magnitude that they affected the result? For me, that would be the most important issue, because the way to dispose of that is to ask, people voted, okay? Yes or no? Or votes counted, yes or no? Were they then transmitted, the forms 34A, were they, the physical forms, were they recorded? Were they transmitted to the constituency tallying centers and to the national tallying centers? Yes or no? Were there issues in terms of problems with counting? Were there errors? Let's look at the error report. If the errors are significant, probably nobody got the 50% plus 1. That is easy to resolve. However, there are other issues. But you see, these are issues that come, and recall that many, as Elisha is pointing out, many of the petitions and their affidavits in support of the petitions are faulting the process at the tail end. You don't hear anybody saying that, look, from the beginning to about when the chairman decided to unilaterally, quote unquote, announce the result, we didn't have issues largely. So in that sense, issue number 8 would be the most critical. There'll be other issues. Did the IEBC conform to the technical standards of election management? Are they verifiable? Are they accountable by the standard of the Constitution? Was there an interference with the uploading and transmission of the forms? Were there differences between the forms that were uploaded and what you finally got at the National Tallying Center, and then what were given to the agents and the polling stations? I think those are secondary issues. For me, primarily, I would think it would turn on
number 8.
Number 8.
Yes. All right.
Yes. To put it broadly, when an election court sits, an election court standard determines 3 broad issues. Number 1, our electoral system has certain standards, principles it must accord to. They are there in the Constitution. You ask, was this election done substantially in accordance with those principles? So when you hear the court saying, was it verifiable, was it credible, was it free, was it fair, by secret ballot, those are principles you will find explicitly set out in the Constitution. So the court determines that broad question, was it substantially in conformity with those principles? Now, if the court finds it was substantially not in conformity with those principles, that becomes the end of the matter. The election must be set aside. If the court finds that it was substantially in conformity with those principles, but there were some transgressions, and with the word substantially, because it's a human-run process, it can never be perfect. So that's why they use the word substantially, because if you want to look at every dot and every cross, you will find them. It's a human-run process.
Is it a qualitative?
Yes. So when you come to the second stage, you ask, okay, assuming there were some transgressions, what was their impact on the eventual outcome of the elections? Our at least the 2017 petition has told us that we are more sensitive to this second standard. If you play around, we can nullify. Ugandans are different. They can tell you there was vote stuffing, but it was not so significant as to, I mean, Ugandans say that, Uganda said it's okay.
Yes.
I would one day understand those ones. I don't
The
understand.
stuffing is not a problem.
It's not a problem,
Yes.
yeah. But here, so you say, 1, was it substantially or was it not? 2, were there any transgressions? Okay. If there were, did those transgressions affect the outcome of the elections, which is actually the issue number 8 that Prof is alluding to. So, principle, that's where it is. But before we forget, the court gave, one of the many directions the court gave today was an order of scrutiny.
Right.
And a lot turns on that. None of us knows what that scrutiny will
We don't know what
reveal.
we'll find.
Yes.
Yes.
But a lot could turn on that. depending on what that scrutiny reveals, because part of what is being scrutinized is the technology itself.
Right.
So depending on what that reveals, then there could be quite a significant change in the trajectory of the petition. These are just issues hanging out there. We cannot sitting here pronounce as where it's going to go. No, it's not even in our remit, but we will keep monitoring as and when the reports begin coming, and we'll be able to, in our own small way, see which call can be made as the details begin emerging.
It's just actually 50-50 here, because everyone who's watching, and Kenyans are say the Supreme Court has done 50-50, however you like it. They have, upheld results of an election, and they have cancelled an election based on two different, of course, elections, but also principles in this sense. And in a sense, the court has departed from its own, sort of standards and ruling from one petition to the other. So literally this, we don't know what the court will do in this way. Would that be a correct way to sort of look at and project that? Because it's been 50-50, we don't know how, they have to almost depart from 2017, 2013 to come up with a different thing.
On the contrary, I think that the court has been quite consistent. 2013, it turned on the evidence, but the standards have remained the same. 2017, I think what persuaded the court was a failure of the IEBC to provide access to its servers. Because I think in a way the court felt the IEBC was daring the courts. What are you going to do if we do not grant? And they felt, and there's some sympathy to that view, and I for example sympathize with that view in many respects. They said that nullifying an election is not something that a court should do lightly. That it has to be so bad that the reasonable Kenyan on the streets must say that we did not have an election. It has to be that bad before a court nullifies an election, number one. And number two, a court should not nullify an election on the basis of an examination of discrete elements or parts of the process. It should take a big picture approach. Look at the entire process. And then so you apply it and ask yourself, from the beginning to the end, were there things that went well? Were there things that were not done according to law? What is the magnitude of the transgressions? Was it minor? If it was minor, can you say that from a big picture approach, we did not have an election? So from that perspective, it will become very, very difficult to nullify an election. So that is a challenge, but we will see. The challenge, because you have to see, and this is the element in which you have to look at it from the perspective of Kenyans.
Right.
What do Kenyans think about? There's a lot of drama, granted, around particularly events at Bomas. But when Kenyans take a big picture approach or look at this election, what do they say? I leave it at that.
Yeah, the point, Prof is right, that in terms of the 2017 standard, I mean, there was the issue about whether or not IBC granted sufficient access to the servers. Now, the issue is that if we are talking about transparent electoral process, verifiable process, how do you verify? You verify by going back to see what happened.
Right.
If you deny me a chance to go there, if you say it's impossible for me to go there, then you are
there's opaqueness.
There's opaqueness. I use the word in the vogue.
Yes.
In the whole process. So the court nullified that election at that very principal level. The court didn't dig deep into the minor details. It is the dissenting judges who went and said, no, if you go beyond that, you'll discover there's nothing wrong with this election.
Right.
I think that this thing has helped in a way. There is a sense in which there was a greater sense of sensitivity to the officials, even the way they kept reporting to the public and the way they kept doing their things, Whether they finally got it right, that's the jury is still out there. But there's a way in which the standards keep growing. People are saying, hey, you know, we must be careful this time around. We want to see. The court has said, now give these logs, give this. We want to see how fast they'll give it. I saw when the parties went back to court this afternoon, the IBC lawyer saying we have already begun complying.
Right.
And that's something positive, Mr. Smart.
2013, there was a problem.
There was a big, 2017 was a big problem. We said we can. Now people are saying within the first few hours, from the time we gave the orders, we have already begun complying. You just get clarifications on this and this and that, but we are already complying. Even as a nation, we can be proud of that. That is something that is positive. You look forward and say, no, we may not be very perfect as society, but I'm happy that we are getting there. And just the flip side of it, and I think I want the discourse to get there, the understanding to get there, that it's not whether or not a party wins or loses this petition. It's about how it enhances the value of our governance.
Right.
That if this petition serves that purpose of enhancing our governance, we become more transparent, we become, you know, more open to scrutiny, to review, then I think we'll be getting better incrementally as a society.
Would you say, yes, sorry.
It's interesting that every election indicates or highlights a fault in our electoral process. Huh? The one that is glaring now relates to the role of the commission vis-a-vis
the chairman,
the role of the chairman,
right,
in terms of tallying, verifying results, and particularly declaring the results. So if you're looking at it from the perspective of we are making progress.
We're always making better, like, yes.
Certainly, we are looking forward to the court resolving this issue and telling us that, look, this is how the IBC should conduct its business, and this is how it should deal with dissent among its ranks. Yeah.
Yeah, very important, very important. I mean, I just wondered when I saw the DCJ reading about it's not our business to help you sort out your internal affairs, what impact that will have on the reasoning. We leave that jury out there, but I think it's right that this has become now the distinctive question in this petition. In the last petition, it was the technology that was at the core of it. So we derive quite a bit of lessons on what is the importance of technology in terms of verifiability of this. What does it mean to verify, and what is the impact of this technology in that process? So here, the runnings of the IBC Secretariat and team would get better lessons from this. As the new commission takes over, because I think Chebukati's term anyway is coming to an end
in January.
I think on 23rd of January.
Yes.
As the new team takes over, they will have picked their lessons. They will emerge with quite a bit of lessons to carry on their corporate affairs.
All right, a lot of material. Professor Miguel Akech, Alishangwea, we'll take a short break. Another break. When we come back, yes, that question.
Magic.
The Chief Principal, Eldoret National Polytechnic, Mr. Charles Kowech, wishes to inform prospective students that admission for the September 2022 intakes is ongoing. Apply now in any of our diverse market-driven courses. We offer higher diploma, and certificate training in the following courses: Mechanical and Automotive Engineering, Applied Sciences, Building and Civil Engineering, Liberal Studies, Electrical and Electronic Engineering, Chemical Technology, Entrepreneurship and Human Resource, Health Sciences, Hospitality and Confectionery Sciences, Business Studies, Computing and Information Technology, among other courses. Apply now for a course of your choice. Visit www.tenp.ac.ke or call us on 0797 222 666 or 0738 092 126. The Eldoret National Polytechnic, ufundi kwa maendeleo.
Mnamfanya nini huko? Mbona una whisper? Ish.
We, Si atukai. Si tumetoka hospitalini na tiwe peke yako ndo unaweza tupatia ruhusa ya kuwa na mic.
Monica, will you marry me?
African Institute of Research and Development Studies offers you an opportunity to start your career journey with us. Admission for September-October 2022 intakes is ongoing in all our campuses in Kericho, Nakuru, Lodwar, Eldoret, Kisumu, and Bungoma.
All right, with all due respect, welcome back. I do have Elisha Ongoya and Professor Migaya Ketch, and we're trying to make sense and understand the Supreme Court process and what's happening next and things to look to as tomorrow, sort of the actual dance actually starts and begin. But if I remember correctly, the last Supreme Court made a whole meal out of the process. And something to the extent that if the processes, election is not an event, correct. Elections are processes, yes, yes. Right? And that still stands today.
Correct.
And tonight, where we see it is that last bit of the process is where the contestation is, if you like.
Yeah, it's important to know that although the court said that elections are a process, the court is not reviewing the entire process. The court is reviewing such part of the process that the parties themselves have taken issue with. Because courts eventually are bound by what parties come before it and do what you call pleading, what they claim and what they ask from it. If you study these petitions very well, apart from one of them that raises issues about the voters register, but when I looked at the issues, I kept wondering how that fits in the scheme of issues as framed. These issues have to do with the very last phase. How are these results transmitted from the respective polling stations? And how are they tallied at the National Tallying Center and the final declaration or decision to declare and the declaration itself made? So that's the focal point of the petitions that are before the court. So it's that part of the process that will be of great interest to the parties in this process. And my reading of these issues is that the court is interested in understanding significantly the integrity of the technological system, right. The integrity, what security was put around it. Was it immune from mischief? Was it sufficiently immune from mischief? The way this should have been framed lead me to that conclusion. That's what the court will be looking at. So that as the parties spend their 3 or 4 hours, whichever hours they've been given, the more the energy they spend on that issue, the better their chances from the way the issues have been framed.
Prof.
Back to this question of process. I think we go back to the 2017 decisions. You compare the majority decisions and the minority decisions. And what was interesting about the majority decision is that they set a very, let me call it a low threshold. Because they said that if we find any kind of violation of the Constitution or the law, we will nullify the election. And that was a test that was set in the Karanja Kabagi case. It's a very low threshold. Any violation we will not tolerate. Will be intolerant of any violation. As you can imagine, you're bound to find violations of some kind. The minority, on the other hand, was saying that is an extremely demanding task to ask of the IEBC. Inevitably, they're bound to be a violation here or there, but one then needs to look at the impact of those violations. So if they have no impact on the outcome, then surely, I mean, the human foibles will say that these things happen, but as long as they don't fundamentally alter the outcome, then these are things that we can't tolerate. So it will be interesting to see how the court then approaches that question. Is it going to approach it the same way as it did in 2017 and say there is zero tolerance for violations?
Right.
Or is it going to have a bit of of tolerance. Looking at it just from the view of the process.
Yeah, I mean, I know you're both teachers of law, and maybe this question is a bit outside your money, but our elections are about trust. And literally, people try to sort of do monkey business around these processes. And we try to create this process so that it is, of course, conforms with the law and there's regulation around it, but people still try to sort of work around it. How do you marry the two, Elisha, in this sense, knowing the true nature of who we are and the things we try to put in law?
To create a proper constitutional culture, I'm not looking at it broadly, and legal culture, where people, the constitution means something to people at a fairly spiritual level, and the law means something to people at a fairly spiritual level, where somebody, without being observed, would seriously reflect and think that doing the right thing is the right thing, requires that cultural shift and that trust element. That's difficult to legislate. That requires a behavioral change. It requires introspection. It requires conversations people have very informally to know that we are better off as a society by doing just the right thing. It is my hope that my country, Kenya, will approximate that. We may not fully reach it, but at least we'll push towards that. In my own view, we are doing significantly badly on that index. We need to push so that our trust is very low. And you know, we did not look far. Just the behavior of this commission in terms of the back and forth you have seen is itself, it shows that level of bad manners, the distrust at that level. But let me tell you something smart, and obviously we know this. The Electoral Code of Conduct obligates every candidate and every political party to constantly tell the electorate to have confidence in the election management body, expressly. You have an obligation in law to constantly remind voters
to stay within the line,
to have faith in the IEBC. It says expressly. I don't know whether the IEBC itself has a corresponding obligation to remind people by conduct that you must have faith in us. From what we've just in.
Maybe they should remind themselves.
Yes, the court kept saying, you know, the two factions.
Yes.
Today you had the word factions used by the Chief Justice herself.
For the first time.
Yes, for the first time.
Yes.
To imagine factionalism in a body that you're supposed to have trust in is to stretch the limits of trust fairly widely. So that is something we need to. The law will not solve that. Let's take it to the bank. The law will not make us have more faith. We need just have more introspective men and women who understand the gravity of their obligation, who understand the hopes and aspirations that they carry with them, so that over time we do this. I was just asking myself today, the IEBC is just a constitutional body like that Supreme Court. They're just both constitutional bodies. Imagine if a half of that Supreme Court on Monday went to Serena and said, you know, those things those people are doing there, we don't take ownership of them. Where would that leave us? And it is not different, by the way, from what the IEBC did. It's not different. Both of these are just constitutional bodies discharging constitutional mandates.
Right.
So what would we do if those 7 people you saw there today, the men and women, a few of them just, coincidentally, there are 7, by the way.
Yeah.
IEBC is 7, the Supreme Court is 7. If 4 of them also walked, and we found them at Pan-Africa, and they also gave a press release, and that leaves us where we are. So some of these things, the law will never solve them. The only solution is they should not happen. They just should not happen. When they happen, they're just disenfranchising. And let's not think about how next year we'll tighten the law to make it impossible for commission to do this.
Yes.
No,
Yeah.
the law will not solve these problems. We just need people to think about their goodness as men and women that drives them to do what is just and right.
Yes.
Actually, as a matter of fact, we have very good laws, electoral laws.
Correct.
They're some of the best in the world. But there are 2 things that I think the law might be able to do, whether in terms of the existing law or in terms of the law that we could have if we reformed the Constitution, for example. So 2 things. One has to do with the appointment processes. You know, the interesting thing is that the IEBC declares that it is independent.
Yes.
And I always found it curious when we were making the Constitution. We declared it is independent by name. But in practice, in action, it is anything but independent. So what guarantees independence has to start with the appointment processes. And this is where Kenyans have to be vigilant, to be able to say that, look, what we always get invariably, if you're talking about all of these constitutional commissions, the judiciary, name it, are very opaque appointment processes. They give us a veneer, an appearance of transparency, but they're never transparent. And so it's very easy to manipulate an institution because the person that helped you get the job is not, or the thing that helped you get your job is not your competence, but it is your allegiance to somebody, a puppet, a puppeteer somewhere.
Yeah.
You know, so that is one. If we did that, then we can truly have independent institutions, because you'd be able to tell somebody that, look, I am here because of my competence, not because of your favors. Number one. Number two, and this goes back to BBI. BBI had many bad things, and I think the authors were carried away in many respects. However, there's one thing that it wanted to do that needs to be done in this country. And that is to make the presidency less salient, less important. And the only way we do that is by having power sharing.
Distribute power across.
In the executive.
Yes.
I mean, look at the other positions, the other elections. You even have people conceding, they have meetings after the election, they congratulate the winner, and they pledge to work together, they shake hands, and that is the end of it.
But the president has it a lot.
Exactly.
I mean, literally, the president decides many things that happens in this country.
Exactly.
Almost everything.
Exactly. So we need to deal with that. If we don't deal with that, we will be like the proverbial in my mother tongue. We talk of what is this animal that goes around? Is it the rhino? The rhino that, no, it's not the rhino. It's an animal that forgets very quickly. The
warthog.
The warthog. You know, we're just like warthogs. Every 5 years, we come back. We have forgotten the challenges we have. We run around 5 years. We come back. Same dance.
Right. But come to think of it, Prof, just how better can you make this appointment process? You know, I keep saying the last IBC of Kinakombe and so forth, including Chebukati, that some of them just walked away, was actually even appointed by the clergy. I mean, that's how far we went in terms of just now moralizing the appointment process.
Yes.
This IBC here, the 4 commissioners, in fact, all of them, were appointed by a fairly multi-sectoral team. I mean, one of the people who was on that panel, I must disclose, was my university roommate, who was sitting there to interview them. And I know he's a good man.
Right.
And I mean,
there's no reason to impeach him.
But goodness goodness is demonstrated. They have to tell us that, look, these are our mark sheets.
Yes.
So we gave, I mean, you and I are teachers.
Yes.
When you have really broad variances in your marking, as a candidate scores 70, another one scores 40, then you have to ask yourself, why is it that one has 70? Or if you're marking, let's say you're examining a thesis, one examiner gives the candidate 70 and the other one gives the candidate 40, there's a problem.
Correct.
So you have to be accountable to one another.
Correct.
The thing that they don't do is that they don't account to us and tell us that, look, why is it that the same individual, somebody gave him 70, somebody gave him 40? It doesn't add up.
Okay.
I think we have a problem. Our problem is bad manners, Prof.
As your final thoughts.
Yes. It's bad man. We need just to instill a culture of good manners in our process. Just very finally, what Kenyans are to expect from tomorrow is these advocates you saw there robed in black will now begin making what are called their oral highlights. Remember, all the arguments they are going to make are already before the court. Each of these parties has filed at most 40 pages of arguments in writing already before the court. I think what the court could as well say, by the way, we have finished, we're going to read our judgment today. But the court, as an integral part of the underlying principle of transparency and accountability, and because of the public interest nature in the matter, the court also wants you to hear what it will hear, so that when it returns to the ruling, there's a sense of openness that those things you heard, they are the ones that have informed this judgment.
So it means the next 2 days
is
the next just 2 days for the show.
It's a show of sorts, some prowess and so forth. Otherwise, the court actually has an idea of where this is going to, subject to the outcome of the scrutiny, which I suspect none of us has an idea, perhaps except the IEBC, which is the custodian of the system, which will know what exactly is in the system.
Final thoughts, Prof?
I just hope that the court will come up with a decision that keeps the country together. It's that simple for me. It's a really...
I have to ask additional question to this. I have pressed my director to go, but is this the court's remedy to do this? Because sometimes people can ask things of the court that the court has no tools whatsoever to resolve.
But it seems we have put the court in that position. It seems we are unable to manage our affairs. So somebody has to do it for us.
So basically this fallout has to be decided by the Supreme Court. However it is, moving forward, asking even things that the court absolutely cannot grant.
No, the court threw out 2 petitions today saying the ones that we can't grant will just send you away. The 2 petitions were taken off. There's one ruling I haven't seen, the one in Ruben Kigame's matter, but I've seen the one in Moses Kurias. I think it was meritoriously thrown out.
Yes, certainly, I agree.
I have to look at it. So the court will of course shed off some things as it has done today. By the end of it all, the court has taken into account something called public interest. And I think keeping the country together is a great public interest as in my wildest imagination.
What do you expect?
I have no expectation at the moment. I'm an observer. I expect a decision. A decision around those 9 issues.
9 issues?
Yes.
All right.
Yes.
Prof, what do you expect? A decision as well?
Some resolution of these issues with finality.
All right.
But ultimately, it's inevitable that there'll be some people that are happy, there'll be some people that will be disappointment. It's the nature of judicial proceedings.
Let me say this. Next Tuesday, at time like today, we'll have the decision and have possibility for us to go through it. And I'll have to have both of you to go through it and see if you are right as observers or wrong. And but with all due respect, let's stay with a theme that we've started here and stay with the new elected leaders and their profiles. 68 new MPs will be shuttling between courts, fighting all manner of charges, including fraud, murder, defilements, corruption, while busy as well serving the electorate. Tonight, let's focus on 2. One is the new elected governor of Kakamega County, Fernandez Baraza. Congratulations to him, by the way. He's the new governor of Kakamega County. Before this, he was the CEO of Kenya Electricity Transmission Company, KETRACO. Before that, he was at the Kenya Tea Development Agency Limited, KTDA. And before that, he was at the Kenya Airways and East African Reassurance. Basically, he's a man who knows how to get public jobs. But let's focus for a minute on his last appointment at KETRACO, his last public service, before being rewarded by the great people of Kakamega County. So he quit his job as CEO earlier than expected because he wanted to vie for the seat he has just won. It was a way before IBC's timeline for candidates to have resigned to vie for the political seats. The question is why? Well, a very little story for a minute. This one involving another governor candidate who has also won his seat, and that's new Mombasa governor, on the screen now, Abdul Swamad Nasir. So, Honorable Abdul Swamad was the Public Investment Committee chairman, and the PIC was conducting a little investigation. A special audit raised by the Auditor General had landed on PIC's desk. The special audit by the PIC of the Lake Turkana Wind Power Project, LTWP, stay with me, had raised several issues. First, the project was the single largest private partnership in Kenya, and the committee was told that no risk analysis was carried out to establish challenges to the project would have had. Secondly, the committee sought to establish how a project meant to alleviate energy costs in the country ended up doing the exact opposite. It added additional avoidable financial burden to the government and the Kenyan taxpayer. Thirdly, and most importantly, KETRACO initiated excess payments of over 785 million shillings to the Lake Turkana Wind Power Project. That's LTWP. And that was for one project alone. Well, you ask, how does that happen? I want to answer that question too. Well, with all these questions needing answers from the accounting officer, Mr. Fernandez Baraza, the new governor of Kakamega County, he quit and promptly announced his interest in Kakamega County gubernatorial seat. PSC chairman Abdul Samad Sharif Nasir questioned Baraza's resignation, saying that he vacated office weeks before the deadline set by the Independent Electoral and Boundaries Commission, IEBC, for public servants eyeing elective seats. He said, and I quote, I find it a bit worrying that the MD resigned before he met us. That's what he said. Nasiri's sentiments were echoed by Likoni MP Mishimboko, who wondered whether Baraza was avoiding MPs to escape grilling. And I quote, says, I don't know whether he's part of the cartel or not. We are just surprised by his move. That's what she said. The PIC, however, went ahead in its report dated 31st May 2022 and signed by the chair, and it recommended the following: that the EACC should investigate the Ketraco CEO, Fernandez Baraza, on contract management and implementation of the project because it costs taxpayers money. Mr. Baraza, on his part, said this: well, I saw no issues at all whatsoever. Anybody who thinks that I stole money should go to court and sue me. I'm ready to face any panel to clear my name, said Mr. Baraza. Well, he wouldn't be facing any panel. He's the Kakamega County governor-elect. Let's focus on the second one for a minute. The great people of Mogotio constituency, Bomet County, elected Ruben Kiborek as their new MP on UDA ticket. Mr. Kiborek has been an aide to a former cabinet secretary, and he had profiled himself as a Jubilee politician before his election as MP for Mogotio constituency. On December 23, 2018, Mr. Kiborek was accused of intentionally and unlawfully defiling a child of a 16-year-old in Nakuru County. Charge sheet seen by court reporters also indicated he faced an alternative charge of committing an indecent act with a child. The crime is said to have been committed at Sarova Woodlands Hotel in Nakuru. Mr. Kiborek was arrested and held 4 hours by police as investigations were done at Bodeni police station, where he was subsequently presented in court and denied the charges before the resident magistrate, Yvonne Hatambi. Through his lawyer, Kiborek pleaded with the court to release him on reasonable bond terms, saying he was a Kenyan, not a flight risk. He pleaded he was willing to comply with orders and would attend court, underline this, when required. His father, who was in court, said he would ensure his son attended court. The court heard that the accused was young and is in the process of setting up his life and therefore deserved release on bond. Kiborek was released on a bond of 300,000 shillings with a surety of similar amount. However, this would be the last time the courts would see the new MP for Mogotio constituency. The case has been adjourned for a record 12 times over reasons that the victims say cannot be justified and an obvious abuse of privilege and power. In a letter addressed to the court administrator, lawyer Donald Rabala for the family complained of what he termed unnecessary delays that has rocked the matter, saying, and I quote, justice delayed is justice denied. The delaying tactics have now lasted for the last 3.5 years. It is not only prejudicial to the minor, but an affront and a blatant show of disrespect to the girl child who only seeks justice from the court. Justice delayed is justice denied, he said. The case has never picked up, and there's no reason to believe it will progress now that the Mheshimiwa will be very busy making very good laws for you on this country, and obviously talking about integrity and all matter of things. However, and as I say here, the people have spoken. That's God's case, no appeal. With all due respect, my name is James March. Do have a lovely night. Thank you very much to my guests, Elisha Ngoya and Professor Mugaya Ketch.
Thank you, James.
Thank you very much.